Welcome viewers to part 3 of our screencast on long-term care issues in Medicaid. My name is Richard Land. I'm an attorney and a member of the Danbury, Connecticut law firm known as Chipman Mizuko. In parts 1 and 2 of this screencast, we talked about the kinds of services Medicaid covers and the asset and income criteria for eligibility for Medicaid. Now in this part 3, we'll be talking about how eligibility can be jeopardized if you make certain transfers of property in order to qualify for Medicaid. As you may expect, the Medicaid program includes rules that are designed to thwart the perverse incentives to transfer assets so you can qualify for a welfare program. In part 3 of this screencast, we will be talking about the rules relating to transfers. This is the main idea. If you need Medicaid benefits and you make a transfer, or your spouse makes a transfer for less than fair market value, you may not qualify for Medicaid benefits. In other words, if you make gifts in order to qualify, you may be disqualified. When you apply, the application process will include a review of your records for the previous 5 years to try to find out whether you made any gifts in that 5-year period. If no gifts can be found in that period, there will be no disqualification even though you may have made very large gifts 6 years ago. That's the general rule, that a gift made within 5 years before the time you apply will disqualify you. But there are exceptions, and here they are. You can transfer your home to your spouse, to a child who's under age 21, to a blind or disabled child, to a brother or sister who owns the home with you and who's been living in the home for 1 year, or to a child who resides in the home for 2 years before institutionalization and who provides care which avoids the need for institutionalization during that 2-year period. That can be a very important exemption because it's not unusual for a child to decide to live with a parent who needs help. Before you become eligible for Medicaid benefits, there are no restrictions on your transfers to a spouse. But the only transfer you can make to your spouse after you become eligible is a transfer to give your spouse the Community Spouse Protected Amount, which we talked about earlier. And keep in mind that transfers to certain disabled children are exempt. What happens if, when you apply for Medicaid, the Department of Social Services discovers that you've made gifts during the 5-year period before you apply? The answer is that, unless the transfer is exempt, you'll be disqualified from receiving Medicaid assistance. How long you are disqualified will depend on how large the transfer was. That's called the penalty period. The penalty period is the number of months you will not be able to qualify for Medicaid as a result of the gifts you made during the 5-year period before you applied for Medicaid. That period is determined by dividing the value of all the gifts you made during the period by the average private pay nursing home monthly cost, which right now in 2017 is $12,604. So, you determine the value of non-exempt gifts, divide it by $12,604, and that's the number of months you are disqualified. By the way, the number $12,604 is adjusted for inflation annually. Adjustments are substantial. As an example, in 2004, when I first put this seminar together, the number was $7,665. That's an example of what inflation can do. That's more than 64% in 13 years. That means in 2004, $460,000 would have bought you 5 years or 60 months of nursing home care. Now, in 2017, $460,000 will buy you only 36 months instead of 60 months of nursing home care. That's extraordinary. In any event, if you made gifts during that 5-year period, it will result in a penalty period or period of disqualification. And that period of disqualification begins at the time you apply or would otherwise qualify, whichever is later. So you go through the application process and you gather all your records. The Community Spouse Allowance is determined, and the Community Spouse Protected Amount is determined, and the Minimum Monthly Needs Allowance is determined. and whether or not you qualify is determined. All of these determinations are made by the Department of Social Services. What if you disagree with the DSS? Then you have an opportunity to make your case at a meeting they refer to as the fair hearing, which is your opportunity to appeal. If you think the DSS did not properly apply the rules, you can make your case. If you think the DSS got some of the facts wrong when it determined the community spouse allowance, or the community spouse protected amount, or the minimum monthly needs allowance, you can make your case about that. So let's say that you've applied for Medicaid benefits and you're successful and the state pays for all your care. Perhaps the state has spent hundreds of thousands of dollars on your care. Of course, the state would like to recover or recoup what it paid out if it can. And the law does allow the state to recover from you, your estate, or even the people you've made transfers to under certain circumstances. Now it's time to talk briefly about the state's right to recover what it paid out to you. The easiest way to think about this is to recognize that if you receive property after you qualify, the state will be able to recover from that property to some extent, with some exceptions, and we'll talk about some of the exceptions in a few minutes. When you die and your estate has an asset in it, the state will be able to recover from your estate. For this purpose, your estate is your probate estate plus death benefits payable under certain annuity contracts you may have been receiving payments from, which you purchased with your own funds. The state also has authority to enact legislation to recover from assets you may own jointly or in trust. But if the state does have a right to recover, it may do so only after the death of the surviving spouse of the institutionalized spouse, and only if the institutionalized spouse has no surviving child who is under age 21 or who is blind or disabled. And Connecticut also has legislation which allows the state to recover from people to whom you transferred property during the 5-year look-back period that we discussed earlier. So if you transfer assets to your children and you must apply for Medicaid within 5 years after the transfer, the state has the authority to pursue a claim against your children for the amount they received, and they may be responsible for paying the claim even if what they received is long gone. Maybe they consumed the gifts by paying their own debts, or maybe it was all lost in business ventures or through divorce. For whatever reason, they may be liable even if they no longer have what you gave to them. If you made a transfer to a trust within the 5-year period, the state also has the authority to bust the trust to recover what the state has paid for your care. That concludes Part 3 of this screencast. In Part 4, we'll be talking about Medicaid and other programs designed to allow the elderly and frail to stay at home while receiving the care they need. And we'll be talking about planning you can do related to long-term care.